In order to complete your trust, we must gather some basic information on the trust questionnaire. For instance, we need to know your names, your children's names, and your contact information. We need to know whom you want as successor trustees and guardians to confirm your intent on a few matters. All of this should go fairly quickly. If it helps, you can pause this video as you go through each page of the questionnaire. Remember, any information you provide is confidential, protected by the attorney-client privilege, and used only for your trust and for us to contact you. The first page of the questionnaire requests basic contact and marital information. Keep in mind, it is usually sufficient to use middle initials when filling in names. However, if you normally go by your middle name, then you could use an initial for your first name. On the other hand, if you want us to use your whole name without initials, then spell out your whole legal name. Point is, whichever way you fill out any name on the questionnaire is exactly how it will appear in the trust. The next page of the questionnaire asks you to list any prior marriages and to provide your children's names, ages, and dates of birth, and the names of any deceased children. The next page of the questionnaire requires your signature confirming that your estate is to be divided equally among all your children, or more specifically, to your descendants by right of representation. When you say to your descendants by right of representation, it means to divide the estate equally among your children, but in the event the child does not survive you, it also means that non-surviving child's share would go to their children. In other words, your non-surviving child's legal children would stand in their stead, and if they didn't have any children, such share would go back to your other children. In no ways does this give any child's spouse any rights to your estate. In the highly unlikely event that no descendants survive you, the trust will specify the estate shall be distributed to your closest living relatives as defined by state law. For married couples, this means half would go to the husband's heirs and half to the wife's heirs. Keep in mind that this is a very remote possibility, so don't get too caught up in this. It is even less likely that something would happen to everybody all at once, meaning you would normally have a chance to readdress this issue in the unlikely event that all your children and your grandchildren predecease you. Again, please make sure both spouses sign twice on this page. The next page of the questionnaire deals with the important issue of young beneficiaries. Please be sure to complete this section even if all your children are grown. Why? Because there is always a possibility a grandchild or other young beneficiary could stand to inherit as an alternate beneficiary. No one likes the idea of an 18-year-old squandering an inheritance on fancy cars, beer parties, and beach bumming. Yet, did you know that without a trust, a teenager would take over a full management of an inheritance the day they turned 18? Not only that, without a trust, you won't even have a say on how and who manages an inheritance while they're still minors. One important function of your trust is that it allows you to control the management and terms of distributions until beneficiaries reach the age you specify. Up until that point, your trustee helps ensure the inheritance is managed wisely and used on expenditures like health, education, college, and living expenses instead of exotic cars and endless spring breaks. While opinions vary on what age to specify, most seem to like the first option we provide. In our experience, the 25-30 clause represents a reasonable, middle-of-the-road approach. The next page of the questionnaire is where you specify your successor, trustees, and guardians. In other words, who you want in charge of the trust and your minor children in case something happens to you. Above all else, choose someone who is fair, responsible, and trustworthy. They should probably be at least 25 years old, though legally they only need to be 18. We also suggest heeding our warning against nominating multiple co-trustees to serve at the same time. In our experience, it tends to make trust administration more difficult and problematic. And this isn't just our experience. It represents the consensus of many longtime trust attorneys, where at legal conferences, they regularly mention that multiple co-trustees consistently lead to the most frequent and expensive litigation. The next page of the questionnaire asks you to provide an overview of your asset base, but remember, we are only asking for rough estimates, so don't spend a lot of time on this. After you have completed the questionnaire, the next step and video in the process is the client checklist. After that, your paperwork is ready to submit.